Well, hello, everyone. Thanks once again for tuning in to the Big Picture Retirement Show. I'm Rick Rivera, your host. Once again, our company is Safeguard Investment Advisory Group. Now, we are fortunate enough to have Joe Hudack back on the show. When we originally had him on the show, we talked about living trusts and kind of defined what a living trust is, advantages of wills and trusts, and all those types of documents, because that's a big question that a lot of our clients have. You know, which is better? Do I really need a trust? So if you have questions about that specific podcast, or I should say, if you do have questions exactly what a trust is, please click the links below, because we have a link that'll take you to that first podcast and kind of define what those documents are. Because what we want to do on this show is kind of take it a step further. For those of you that already know what a trust is or have a good basic idea of what a trust is and the advantages of it, and then of course those of you that already have a trust, there's some misconceptions out there that we want to clear up. So this is kind of like a part two. Those of you that are just tuning in, I'd like to give a little bit of an intro, give you a quick bio on Joe. And basically, Mr. Hudack started his career in real estate managing transactions for Fortune 500 companies. In addition to negotiating, executing, and closing acquisitions for sales and leases, he started and operated his own business. He has served as a corporate and litigation counsel to community associations throughout California. Joe Hudack knows a thing or two about making plans for the future and negotiating terms to make them happen. He spent nearly 30 years running his own business and working in corporate America. There he learned that brokering a deal requires the right balance of understanding, honesty, and patience. He brings those same qualities to his law practice, along with a passion for helping people navigate transitions in life with confidence. Joe earned his Juris Doctorate from Western State College of Law, a magna cum laude, so he could expand his practice and use his talents to assist clients with estate planning, business law, contract review, and drafting and real estate law services. And those of you that are watching this, what I got to tell you about Joe is that I didn't pick his name out of a hat to have him on the show. Joe is somebody that we've been working with for a number of years now, and he's actually done my trust, my power of attorneys, helped me directly with my own estate planning. So I'm having him on the show because he's somebody I work with directly, and our clients have worked with directly. So I know how he is. I know his services. So great reputation, does excellent work. And I'm saying this not because of a bio that I read, it's because I've actually deal with him on a regular basis, and I know the quality of his work and also his knowledge. So he really knows his stuff. So I thought he's a perfect person to have on the show rather than just some random attorney out there. So with that being said, I want to thank you, Joe, again for coming on the show.
Thank you, Rick. I appreciate it.
Yeah, and I know last time we talked about some of the basics of the trust, and one of the questions that we've been getting a lot lately is, hey, you know what? There's a trust for a single person, then there's a trust for a married couple. What are the differences? Why does there have to be a married couples trust versus a single trust? And I heard that there's some confusions about the two. Maybe you can kind of expand on that a little bit more and
Sure.
kind of let us know.
Yeah. So for a married couple, there's always the discussion of what happens to the assets on the death of the first spouse. So we're always looking to see, okay, when either the husband or the wife passes away, what do you want to do with those assets? Where do they go? On a single individual, the assets pass directly as they wish when they pass away, because that's the purpose of the trust. In a married trust, there's sometimes this what we call an A-B split. It's a distribution to two different assets or two different trusts of the assets in the major trust itself. Husbands and wives don't always think of that when they're setting things up. They don't. It doesn't make much of a difference because it's their assets. However, when one of them passes away, they still don't think about it because, well, these are our assets. We created them together. We got them together. We've managed them together. We both use them. We both contribute to them. So they're still mine now that one of us is gone. And that's not always the case in the trust. The trust documents could have a split where some of the assets, up to at least half, could pass to an irrevocable trust where the surviving spouse may not have full and complete access to those assets. They may have access to the income, but not the actual principal that's in those trusts.
So why would somebody then want to set up a trust like that where the surviving spouse would have limited control over half the assets?
Yeah, so most of the reason was because prior to 2017, when the tax laws changed, the estate tax exemption was a use it or lose it type of situation. Gotcha. So if a husband passes away first, the wife would be required to separate the assets, use the exemption so that they didn't have to start selling assets. In 2017, when the law changed, then those A-B splits are no longer necessary because now the exemption from the spouse that passes away can be carried over or rolled over to the surviving spouse. So they can take that person's deductions and use them when they pass away.
Gotcha. So then do they still need an A-B split? Are you saying now?
I wouldn't say now that you need an A-B split. Now we don't need an A-B split. You can create an optional A-B split if it's necessary based on tax laws. But the trust documents that were created prior to the tax law changes required an A-B split.
Okay.
They forced it on the married couple, which is tough because if the house is the major asset, now we've got half of the house in a B trust and half of the house in an A trust. And how do we, deal with that on the passing of the first spouse? It also created a capital gains issue because if there was a long time frame between the passing of the first spouse and the passing of the second, we have the appreciation of the home, and now we're going to get hit with capital gains potential.
Okay, gotcha. Now, obviously, people watching, the podcast right now, they can see how complicated these things can be. So it's always so important that when you're planning your estate or want to make sure that things avoid probate, it's always a good idea, to sit down with a guy like Joe where, he can sit down with you and give you the specifics on your situation because you don't want to get caught by surprises, obviously. So it's important to do that. And then, when going to the A-B thing, this is an interesting question I get from time to time from clients, especially if it's a second marriage. They'll say, hey, listen, how do I protect my half so that way, if God forbid I pass away first, the surviving spouse doesn't go marry somebody else, and now all my assets are going to a completely new family. How do I preserve my half? But at the same time, I don't want to leave my surviving spouse destitute. Mm-hmm. How does that come into play? I know that's a common question. How do you deal with something like that?
That's a perfect example for a reason for an A-B trust. If it's a second marriage and each one of the spouses has children from a prior marriage, it's the perfect opportunity to do the A-B because it will take the husband's assets and the wife's assets, and it will keep them separated when there's a passing of the first. That way, for instance, if a husband has a house and he wants to make sure that his new wife can live in the house, then he can give her a portion of the house, but also give another portion of the house to the B trust, which is an irrevocable trust for his children. The wife can't do anything about it. She can sell the house, but those assets are still part of the B trust. It doesn't take them away and let her give them to other people. It will lock in the beneficiaries of the B trust on the passing of the first spouse.
And then who do you suggest or recommend control that? I mean, who's gonna make sure that all this is gonna be abided by? Or handle? Is it a law firm? Is it a family member? I mean, what's the best way to handle that?
So typically on the passing of the first spouse, there's a trust administration that happens. And usually the trustee of the surviving spouse will sit down with an attorney and go through the documents to figure out what they need to do. That's something that we do as a firm. We will sit down with clients, explain to them what their trust documents say, how they need to treat the assets, and what they need to do. so that they know what their obligations are. As far as protecting it, you can include a trust protector in the trust documents, which would be a third party who would kind of review any transfer of assets to make sure that that's okay and done properly. Otherwise, really, it comes down to the beneficiaries just paying attention to what's there. So if the kids are young, they may not care too much. If the kids are older, they're going to pay attention when mom and dad divorce and then dad remarries, and they want to make sure that the assets go the proper way. They're entitled under the probate code, even though it's a trust, it still follows the probate code, but they're entitled to an accounting. So they would be able to get accounting.
Gotcha. And then some of the listeners or viewers, I know this is probably a question they're going to have because I get it all the time in my practice, is this. Let's say they have, because generally speaking, usually I see that they'll have one of the children or a couple of the children actually be the successor trustee and handle the distribution of the estate for the other beneficiaries. And a question that I get is, well, what if one of the beneficiaries decides to give more to one child versus another, or change the wishes of the parents? What's the accountability for that? Is there any accountability? What's to hold their feet to the fire, so to speak, if they're going to put a child in charge and be assured that they're not going to go against their wishes within the trust?
Yeah, that's a great question. We get that quite a bit, is how do I make sure that my kids follow my instructions? Well, the issue becomes when both parents pass away, or if it's a single trust, if the parent passes away, the new trustee becomes a fiduciary responsibility. They have that obligation to follow the language in the trust. They have to do what it says. So they can't start deciding, hey, I'm going to give Billy, I'm going to give him, 25%. I'm going to keep 50, and I'm going to give Sally, my sister, the other 25. When it was a 1/3, 1/3 split on the three kids,
Right.
They can't change the terms.
Gotcha.
They can set it up into special needs trust or supplemental needs trust to make sure that the assets are protected if needed to be because of family or living circumstances for the children. If the trust includes that language. But the trustee has a fiduciary legal obligation to follow the terms of the trust. If they don't, they can become personally liable for the damages that they cause to any of the beneficiaries.
Got you. So they are legally liable to abide by it. Otherwise, they can be held accountable.
Yes.
So there is something there to kind of let them know, hey, listen, I better be careful on how I better dot the I's and cross the T's on this thing so I don't become personally accountable for it.
Yes. And I always recommend to a trustee when they're doing the administration to work with an attorney. The attorneys are going to help them, protect them. They're going to make sure that they're not getting themselves into trouble. And it's the best way to help make sure that things go smoothly in an administration.
Okay, great. Perfect. It's interesting. I know you've attended, some of our events with our clients. So a lot of our clients, they actually know you personally. Not only know you personally from the events that we do, but you've actually created their legal documents as well. And some of them already knew that I was going to do this podcast with you, and they sent me some questions in to ask you. And I always get even clients asking me questions for their friends. Oh, this family member or this friend has this question, And I wrote down some of the questions here. And one of the questions, I don't know if you're referring to it earlier, but one of the questions was from one of the clients. There's a child that they have that unfortunately is we'll say has a drug problem. Now they don't want to leave him destitute. They are like, listen, there's a certain percentage that we want him to get, but we don't want his hands to be on it. And they're wondering, what suggestions do you have for someone that it could be, whether it's, somebody, a child that, has a drug problem, or maybe they're just a spendthrift and they just know, hey, listen, I don't want this kid going buying a new Ferrari the second I'm gone, because, one child might be more responsible than the other. So is the trust helpful? Is there something that you would suggest can be done within the trust? How do you handle those types of things? I guess that's the bottom line question.
Yeah, so that's a great question. That's all part of what we do, and when we do our initial consultation with clients, we sit down and we ask them, hey, you've got assets. You're saying you've got 3 kids. You're going to make an equal distribution to your kids. How do you want them to receive the money? Mm-hmm. How do you want them to receive the assets? Do you want them to have an outright distribution? Do you want to lay this big, huge check in the lap of your child and hope that they survive and hope that they don't blow it? Or do you want to put strings on it? And that's some of the design that we do in all of our trusts is, for situations like the child who might have a drug problem, you can give them a certain amount of money each month. You can give them a certain amount of money each year. You can condition the distributions to that child on whether or not they've passed a drug test, whether or not they've gone to rehab and gotten cleaned up. There's all kinds of, I tell clients, if you can think of it, we can draft it.
So it's very flexible.
It's very flexible in what they do for a distribution to a child. And that's where the supplemental needs or the special needs trusts also come in, is to set it up so that if kids are on, let's just say it's not a drug problem. Let's say that they were in a car accident and they're disabled and they're receiving government benefits. Supplemental needs trusts are a perfect way to protect the funds and allow the child to continue to receive the government benefits.
Okay, gotcha.
So that's another way to help protect children so that they get a full value of the assets that you want to transfer to them.
Okay, so understanding this flexibility, here's another common question that we get, and somebody had asked me to ask you this. Let me give you the scenario. You have a daughter-in-law, son-in-law. You love them. But you're worried that, if you pass away and let's say, they get a divorce, you're like, hey, I want to make sure my assets stay on my side of the family. Mm-hmm. So is there a way to protect that? Because I know, I'm sure general knowledge is, hey, you can't commingle funds because if you do, that becomes part of divorce. So is there a way for them to actually protect their estate so that way, if God forbid down the road they do get a divorce, the in-law is not taking, half those assets that, were mom and dad's. How do you handle that? I'm sure you've gotten that question before.
Yeah, that's a great question. We always get that concern because, under the distribution mechanisms for the trust assets, they'll go directly to the child, or you can set up the designation of a trust for the child's share. So you can request that your kid set up his own trust. Do it on their own living trust. That way your child, even though they're married, they could create a separate property trust to receive your gift. Because an inheritance is a separate property asset. Mm-hmm. The only time it becomes a community between a husband and wife is if you commingle it, like you said. So if you get a check for $500,000 from mom and dad's estate as your inheritance, and you put it in a joint checking account or a joint money market account, you're considered to have potentially transmuted, the legal term, the fancy legal term. Right. You've converted it to a community asset because now you've given your spouse full access to it. Gotcha. However, if you keep it in a separate account or you keep it in your own separate trust, then it stays your separate property.
Right.
And now, in a married trust, if you are an older married couple and your parents are passing away in their 80s and 90s and you're in your 50s, 60s, then you have your own married trust. Our trust documents allow you to contribute to your own married trust with your spouse separate property assets. And if they go in as separate property, they'll stay separate property. So even if you were to divorce a year or two later, they would still be considered your own separate property asset.
Okay.
So that's an option in our trust language. Okay. And I know that there are a lot of attorneys that do that and do provide that.
Okay. And then obviously that's a conversation you'd want to have with your son or daughter ahead of time and explain, hey, this is the rationale. Here's what our thought process is. So that way, God forbid something happens, they kind of know where you're coming from with that and understand you're trying to protect them.
Yeah, and in that light, we do the same thing. Yeah. We will do that exact same conversation with trustees and beneficiaries.
Oh, okay.
Is to let them know, hey, you know that this is your own separate property.
Okay.
You know that this is for you only. Your mom and dad wanted you to have this. Mm-hmm. They're not giving it to your spouse. They're giving it to you. If you want your spouse to have it, great. Mm-hmm. But if you don't, then you need to take steps to make sure it stays separate.
Okay, great. No, that's some good information because I know I get that question quite often, and I'm sure some of the viewers have that question as well.
It's a very common question.
Yeah. Or maybe they haven't even thought about it, and they're like, oh, you know what? I never thought about that, and I'm glad that those guys brought it up, because they're thinking, I should get that taken into consideration.
Yeah, and the other part of that common question is, when I make a distribution to my child, if they're not here to get it, does it go to their spouse? Yeah. And the answer to that is no.
Right.
Your trust language, if your kid is predeceased you, the language of the trust typically says it goes to your children. So
Yeah, and this is the whole thing. It's so important that when it comes to these types of things, that people consult a professional like yourself, in the sense that you can bring up scenarios and things that they may have not even thought about, that they at least need to be taken into consideration. Because what I always tell my clients is, hey, listen, it's better to know and have the information, and then you can decide what you want to do with it, as opposed to waiting for something to occur and be like, oh my God, I wish I knew this. And how many times we go, oh my God, I wish if I only knew.
Yeah.
So here, by consulting, a professional that knows all the ins and outs, you've seen every scenario. So I guarantee you they're not going to bring something to you that you haven't even seen before. So you can say, hey, here's what other clients have done in your same situation, and in order to address some of these issues. Now, I did have somebody send me a question. They have an autistic child. And some of the viewers, I'm sure, maybe have a special needs child, whether it's autistic or some other issue going on, and they want to know. And maybe you've already kind of answered that earlier. I know you can split up the trust and do all these different things, but is there anything special considerations or regarding a special needs child versus maybe that other scenario that I gave you where somebody was on drugs and I just want to control the money? Is there different considerations, or is it the same?
It's that same supplemental or special needs trust.
Okay.
Either one of those will work for an autistic child or a disabled child, somebody with Downs or something like that. You can protect those assets, but you're going to need somebody to be the trustee. You're going to need somebody who's going to take care of the child. So that's where it's important also to have guardians or conservatorships as the children get older. So that's something you definitely want to get set up. If your child becomes 18, they need to have a conservatorship set up for them.
Okay.
And then the trust can manage the assets to distribute them to the child, but somebody needs to be the one to take care of the child. I mean, you need somebody where they're going to live, who's going to make sure that their needs are met. They're getting fed, they're getting clothed, all those daily needs that happen. You're going to need somebody to do that.
Okay.
But the special needs or supplemental needs trust will be the avenue to go for mom and dad.
Gotcha. And I kind of, not to take the topic off of trust, but I know another important document that people tend to overlook happens to be power of attorney for asset management, power of attorney for healthcare. And I always tell clients, hey, the trust is a great document, and as far as making sure that everything goes to your loved ones, avoiding probate and all the rest of it, really doesn't do so much for you personally. It's great for the kids when you're gone. But while you're alive, what protects you more while you're alive is those power of attorneys. Can you kind of expound on the importance of those documents, or if they're even necessary?
Yes. So for our firm, I believe they're very necessary. I mean, because there are times, and we run into this quite frequently, where we get a call from a prospective client that says, hey, my mom has been diagnosed with dementia, and I've been managing her accounts. I've been helping her pay her bills. But now that she's got dementia, I need to put her in a home, and everybody's telling me I can't touch any of this stuff. I've been doing it for years. Why can't I? And that's when you need a power of attorney document, because those power of attorney documents are what give the authority to a child or to another person, if you want, to make sure that your assets and or finances are managed while you're still alive. The trust is a great document for the trust assets, but assets that are not in the trust don't help with the trust.
Right.
You need a power of attorney for financial management to handle, and almost everybody in this world has a standard checking account or savings account, and that's usually in your own name, and that's where the power of attorney comes in.
Well, a common question or statement that people say, well, Rick, we're jointly on everything. Where would this come into play? And one thing that I bring up to them is, well, your IRAs, your 401ks, your SEPs, your KEOs, you don't own that jointly with your spouse. And especially if it becomes a real estate transaction, God forbid one's in the hospital and documents need to be signed, you're middle of escrow. Yeah. But I guess if, let's say, what does one do? Let's say they don't have a power of attorney, and God forbid something occurs, and now that spouse needs to withdraw money out of an IRA or a SEP or a KEO or handle a real estate transaction because the spouse can't sign documents. Then how do they go about doing it if they don't have that document?
they're going to need a conservatorship.
And is that
And
something
that's
easy to
something
do?
you have to go through the probate court to get, and it takes a while to do it, and it could be expensive to do.
Okay.
I don't personally handle conservatorships.
Right.
You need a lot of involvement from the court and the county and the cities that you live in to help with social services and adult protective services. There's a lot of interviews that go on. So it's a topic that I'm kind of not that familiar with, but the conservatorship is the only other way. If you haven't signed up and done a power of attorney ahead of time, then you're going to need to go do that through the court system, and that takes time.
Okay.
And it's a probate court matter.
Okay.
So that will help with the 401ks and those kinds of issues. For a married couple where the accounts are joint, it's not an issue.
Mm-hmm.
You made a comment about adding kids to bank accounts.
Mm-hmm.
It's not something that I would recommend you do, because what happens if your kids get into trouble and they get sued and they get a judgment against them, and now their name is on your bank account,
Yeah.
and now their assets could be seized by a creditor of your kids,
Right.
and now your assets are gone.
Right.
Or you're trying to fight to prove that they really aren't your kids, but adding them to the account is not a good thing.
Yeah.
If you needed to, you could add them as a signer to the accounts so that the kids could sign checks to help mom and dad pay bills.
Mm-hmm.
But the power of attorney is the best way to go.
Okay, got you.
Yeah.
And no, I appreciate that. And there's one last thing I want to ask you about, because, and if we didn't, I don't know if we covered this earlier. If we did, then you can stop me. But I always, again, another question that comes up, another scenario that I see from time to time is people say, well, I don't need to worry about all that, convoluted stuff. My kids are just going to get everything 50-50. And it's just simple, easy. And, my real estate agent or my neighbor or my friend or the guy I was working out with at the gym told me, hey, all you got to do is just put your, kids on the deed of your home, and that'll completely avoid the probate process. As a matter of fact, and save yourself a couple of $1,000s in setting up a trust. Matter of fact, I had somebody come into my office not too long ago, said that their mom, before she passed, she wanted to make it easy for the siblings. And what she did is she gifted the home to them, or gifted it to them for $1. That's what he said. Mm-hmm. So why doesn't, if everything is simple and sweet and just, hey, you know what, the kids get along fine, everything is all hunky-dory, why don't we just, put their names on the deed, or just gift it to them, as opposed to setting up a trust, and just keep it simple? Yeah,
so that's not a great solution to the problem. The idea that I want to avoid probate by putting my kid's name on the deed, it creates several issues. One is the same thing I just talked about with bank accounts. If your kid becomes liable and they've got a judgment against them, now that interest in the home could be attached by their creditor. The other issue is that when you make a lifetime gift, which means I'm alive, I'm gifting you part of the property, you're making a gift at current market value. So whatever not current market value, what you pay, what the person gifting the property paid for it. So
Gotcha.
For instance, this happened in California quite a bit. People bought their house for $50,000 back in the 70s.
Yes.
Great deal, great investment. They've owned it ever since. Mom and dad are now 85 and they're getting ready to pass away. And, they're looking at, what do I do? I'll just add my kid's name to title on the house. Mm-hmm. So they do that. Well, that $50,000 investment from 1970s got passed on to your kids today. You pass away in a year, your kids go to sell the house, capital gains issue. Why? Because you gifted them what you paid for it.
Right.
So now they've gotten that house or the portions you pre-deeded to them at the value you had. Mm-hmm. So it wasn't at a value that was current market value. Mm-hmm. If you wait until you pass away and that gift becomes a gift at that point, then there's what's called a step up in basis for the house. Gotcha. And you avoid the capital gains issue. The other third issue really is a bigger one that people face that they don't like, and that is the tax assessor comes calling with a new tax bill because now I've got new owners on the house.
Okay.
And in California, we have Prop 13, which helps people keep their home property taxes low, which is great. Now I've got low property taxes, but I just added my kid to the title of the house. The tax assessor says, okay, if you did it prior to 21, not such a big deal because the tax laws were different, but Prop 19 changed everything. Gotcha. And in Prop 19, it now says, oh, okay, it's your primary residence, Mom, and you just added Billy to the title. Billy doesn't live there. He lives in, Northern California. Okay, that's a new owner. It's not his primary resident. It's not exempt
Wow.
from reassessment.
Wow.
So now the house is going to go up in value for real estate tax purposes. So when the real estate tax bill comes, remember, mom and dad bought the house in the 70s. It's been slowly growing because of Prop 13.
Right.
Now it's 10 times the tax bill.
Okay.
And that's a huge problem.
Yeah, that could be a big nightmare.
And so that's one we tell people to avoid all the time. We don't want to do that. We don't want, for any reason, to add a kid to title because of that.
Wow. So somebody just trying to save a couple of bucks on a trust can end up costing themselves tens of thousands of dollars in taxes while they're alive, and even to the kids after they're gone.
Right.
So again, folks, always consult a professional. Again, whether you use them or not, at least maybe they can give you some tidbits of what to look out for before you make that plunge, and take in recommendations from the guy at the gym or the next door neighbor or the real estate guy that doesn't specialize in law. So I know these topics can get real complicated. So those listeners that are tuning into this show today, again, want to thank you for listening to the show and watching the show. There are links below. So if you want to get a hold of Joe directly, there's links down below where you can get a hold of Joe and ask him questions about your specific scenario. That way you're not getting a bunch of generalities. And I know these legal documents can get real confusing to the average Joe, so to speak. And if you want to give us a call, you have questions about your retirement planning, that's what we specialize in at Safeguard Investment Advisory Group. Again, there's links below. We have a lot of good information. Feel free to give us a call as well. We also have a radio show that airs on 590 AM. You can catch us on Spotify, Apple Music. Once again, I want to thank everybody for tuning in. Really appreciate your time. And Joe, thank you so much for coming on. Thank you so much. I really appreciate it.
Thank you, Rick, very much. Thanks for having us on. Appreciate it.
My pleasure.
For you.